Hi, this is Larry Lessig of Equal Citizens. Today, the Supreme Court decided the incredibly important case of Gill versus Whitford, the partisan gerrymandering case, and the internet has gone berserk. Because, as the internet says, the Supreme Court has, quote, punted, God, do I hate sports metaphors, but punted on the question of partisan gerrymandering, and that means it leaves it to the political process, which, as we all know, means it is hopeless. But here's what I think the internet is missing. In that decision, there was an opinion by Justice Elena Kagan. And Justice Kagan said, yes, I agree, the plaintiffs have not established that they themselves have been harmed by partisan gerrymandering, and they need to establish that first before we decide whether partisan gerrymandering violates the Constitution. But she also said, when you're back there making that harm clear, you should also make it clear to us exactly how you think partisan gerrymandering violates the First Amendment. Because, as she said, the First Amendment protects a right to associate. It protects it against state-imposed rules that burden the right to associate. And what political gerrymandering is a state-imposed rule that makes it harder for one party to aggregate, to associate with people of their party because it makes it harder for them to be able to win. And so she signaled in that opinion that she believes this might be a viable way to attack partisan gerrymandering. Now, two important facts about that opinion need to be kept right in the foreground of this discussion. First, she got 3 other justices to join her opinion, which means 4 justices in this case signaled they believed that the First Amendment might be violated by partisan gerrymandering. But the most important fact is that she stole, or I guess they don't call it stealing in the Supreme Court, but she borrowed the argument, let's say, from an opinion written by Justice Kennedy, who first articulated the idea that partisan gerrymandering might violate the First Amendment. So what that means is 5 justices, you count them, 5 justices, that's the magic number, 5 justices, or just 5 justices, have now said they believe that the First Amendment might be violated by partisan gerrymandering. And here's why that is so incredibly important. If that principle is established by the Supreme Court, then what that means is something much more important than just ending partisan gerrymandering. What it means is we can use the First Amendment to defend political equality in many contexts, and in particular in the context that we've been fighting, which is the winner-take-all system for the Electoral College. Because the Electoral College is also a system that burdens people's representation based on their political views. If you happen to be a Republican in Massachusetts, your view will never matter in the presidential election because you will never have any representation in the Electoral College. If you're a Democrat in Texas, your view will never matter because the Democrat in Texas will never prevail in the state to win any votes in the Electoral College. So this principle of the First Amendment could fundamentally affect the argument we've been making in the context of winner-take-all in the Electoral College and give us a chance to establish, maybe for the first time, a core principle of political equality inside of our republic. So I apologize to the internet for bringing gloom and doom to their prophecy of gloom and doom by telling them that, in fact, this opinion is not necessarily the end of the world. Indeed, could be the beginning of the fight for successfully defending political equality. And I think it's important to spread something other than gloom and doom because God knows we have way too much sadness and gloom in the political world of America right now. That's our view at Equal Citizens. You can follow us at equalcitizens.us, and you can share this video because everyone knows we need a little bit more happiness in our political process just now. Thanks very much.